All right, welcome everybody to our Criminal Justice Connect series. Today we're really excited to have Shannon Danley here, our Executive Director of Pretrial Services. She brings a wealth of experience and knowledge to bail practices and pretrial services in general. I'm Catherine Kilgore, Criminal Justice Advisory Board Administrator. I help facilitate and kind of coordinate these presentations, and the topics were selected by members of our community of things they wanted to learn more about in the criminal justice system. So we do things like this every other month or so, and have had a number of sessions that are available on YouTube as well. If you want to look at any of the other sessions we have, I can send those links around at a later time. But without further ado, I will turn it over to Shannon and turn off my camera. And thanks for joining us. And Shannon, take it away.
Thank you, Catherine. Yes, my name is Shannon Danley. I'm the Executive Director at Dauphin County Pretrial Services. I've been here almost 24 years, so that's probably why they've asked me to do this. I've been around quite a long time, and I've seen a lot of the practices evolve through the years, including the practices here at Pretrial Services, as well as bail setting practices in the system in general. I'm involved in the front end of everything, including being present for arraignments, working with our MDJs in setting their bail. So they thought maybe with all of that, I could handle this, so I'm going to give it my best shot. So for today's purposes, we want to highlight a few items here. I've been asked to cover what exactly is bail, what goes into setting bail, what are the different kinds of bail, and what are some conditions of bail, and how do you go about posting bail. I'll give you a little bit of history and a little pretrial 101, as we like to call it, and I'll go over the role of Dauphin County Pretrial Services, the assessments, the supervision, the reporting that we do, and generally our role in the criminal justice system. So the first thing we wanted to cover is what exactly is bail. A lot of people think they have a pretty good understanding of exactly what bail is, but there are a lot of factors that go into it, and there's no one kind. So simply put, bail is the amount of money defendants must post to be released from custody until their trial. Bail is not a fine. It's not supposed to be used as a punishment. The purpose of bail is simply to ensure that the defendants will appear for trial in all pretrial hearings for which they must be present. When you Google what is bail and what is the definition of bail, you can find lots of definitions. Some a little more simplistic than this, some a little more complicated with a little more legal jargon, but I chose this one specifically because it does cover not only what bail is, but what bail is not. And specifically that bail is not a fine and it's not supposed to be used as a punishment. That is something that we do work with our judges on quite frequently, and reminding them that, you know, the person is still innocent until proven guilty, so we can't use bail as a way to punish them for a crime that they've not been found guilty of. I also like this definition because of where I got it, from the American Bar Association. That means a bunch of legal heads got involved and decided this is a good definition for bail, and they're from both sides of the aisle. We have the district attorneys and the prosecuting attorneys, as well as defense attorneys, all agreeing on one definition. So I kind of like that one the best, and I thought that would be the most appropriate because it covers just a little bit about everything about bail. Now that we know what it is, one of the things that judges have to do is decide what goes into setting that particular bail. And there are a lot of things that the judges have to consider. And hopefully you can see this all on your screen depending on how you have your settings. So it is a lot in one screen, and there are a lot of things they have to cover. There's a total of 10, and we'll go right to number 10 because number 10 is kind of all-encompassing, and it says any other factors relevant to whether the defendant will appear as required and comply with the conditions of the bail bond. That's pretty broad. That can include anything from a risk assessment, some information from the arresting officer, any information that goes from, you know, other cases that they've had. But all of these things they have to consider, and it is quite a list when you've got a limited amount of time with a defendant to talk to them. most of this is also kind of common sense. You've got to weigh in the nature of the offense. You know, obviously, if it's homicide, that's going to be taken way more seriously than maybe a first-time retail theft. Another factor is the defendant's employment status and their history and financial condition. Obviously, bail is not supposed to be a punishment. You're not supposed to, you know, hit them over the head with bail, so to speak. So you don't want to set it so high that they can't make it. So they have to factor in whether or not they are financially able to post that bail. And then the nature of the defendant's family relationship, that's their ties to the communities. Do they have family in the area, someplace to stay? The length of the defendant's residence in the community and any past residences. Do they move around a lot? Are they originally from the area? Have they only lived in the area a short time? The defendant's age, character, reputation, mental condition, whether addicted to alcohol or drugs. That's kind of a broad one as well. And that's a lot to sum up in just a few minutes, especially if you are not necessarily trained in defining what a mental condition is or an addiction to alcohol or drugs. But age and character, you know, that's kind of the character and reputation is also something that's done fairly quickly on the draw as the judge is talking to the defendant. If the defendant's been previously released on bail, whether he or she has appeared as required and complied with the conditions of the bail bond, sort of their history on bail. If they did well on bail before, then there's a good chance that we can probably release them on bail again, or vice versa. If they haven't done well before, then maybe we need to consider a different type of bail this time. Whether the defendant has any record of flight to avoid arrest or prosecution or escape or attempted escape. So anybody who's been charged with escape or has a previous failure to appear, then you want to reconsider what kind of bail that you're going to be setting. And the defendant's prior criminal record, if they have a long history of being arrested, or more importantly, even a long history of convictions, then you know there's a pattern here. The more somebody's arrested, the more likely they are to rearrest. And of course, any use of false identification. You know, if they're not even presenting who they truly are, what's the chance they're going to take responsibility for their bail? So the judges are trying to surmise all of this in a short amount of time in talking to the defendant and asking them some general questions. And some of this is also stuff that we would cover doing an interview and part of our assessments. Then the judge has to decide what kind of bail they want to set, because there is more than one way of releasing a defendant or detaining them. The first kind is a monetary condition, what we also call a straight bail. The cash amount to be paid in full, maybe, and it could be refunded at disposition. For an example, a cash amount or a straight bail, the judge might consider a $25,000 bail for, say, possession with intent to deliver drugs or in the community. So they would set that straight amount, and the defendant would have to come up with that amount of bail to keep from going to jail. We have percentage bail, which is basically a subset of monetary conditions. It's not its own kind of bail, but I do have it separated out because sometimes a judge can say your bail is $25,000, but I will accept 10%. And in that case, the defendant then can come up with just the $2,500 and pay that $2,500 instead of the $25,000 in order to keep from going to DCP. And again, that also could be refunded at disposition. And then there's nominal bail. This one isn't seen very often. It's mostly used when we have a defendant that also has other detainers that might be holding them. And it just simply means a very small amount. And we commonly see the judge set maybe $1, maybe $100 bail. They'll use that in a situation if they have a probation detainer or if they're being held by immigration or something like that. And they just want to put something on them that will also give them time credit so that while they're in the jail, they will also get time credit for that case as well. We also have unsecured. That is a non-monetary condition where the judge sets, again, maybe a $25,000 bail, but instead of actually having to come up with any money, it's kind of like an IOU bail. The judge will set the $25,000, but no money has to change hands in order for the defendant to be released. Then we have non-monetary conditions. that means that there's no amount of money set at all. But then the judge can set conditions that go along with it. So the judge might say, well, I'm not going to put a cash amount on you, but I do have other conditions to add to your bail. So then the defendant can be released, and there's no concern about money changing hands. And the defendant's basically promising to appear. And then there's ROR, which is released on your own recognizance. No cash amount is set, and the judge cannot apply any other conditions to that bail. It's just you're agreeing to promise to show up, and that's all that's being required of you. Now, I talk about bail conditions in there a little bit. Anytime a judge releases somebody on bail, whether it's ROR or straight cash bail, there are conditions that go along with it. These conditions that I've listed on this screen are conditions that apply to anybody that's on bail, and they are on the bail bond itself. He has to appear at all times, required until full and final disposition of the case, obey any and all further orders of the bail authority, give written notice about their change of address within 48 hours, cannot commit any further crimes or conduct against a victim or witness in the case, and no further criminal activities. So don't get rearrested. That doesn't help in it at all. But those bail conditions are on every bail bond and apply to every defendant that's arraigned. The judge can also set other conditions as well. I mentioned in the non-monetary bail that the judge can say, well, we're not going to require any money up front, and we're not even going to put a dollar amount on you, but I do have other conditions. And this is where those other conditions would come into play. And these conditions can be set on any kind of bail except for ROR. ROR, the previous screen's conditions, are the only conditions that can be set. Anything else, any of the other kinds of bail, these other conditions can apply. And it can be anything from ordering no contact with the victim beyond just not reoffending against the victim. Also ordering evaluations for and recommended treatment for mental health or drugs or alcohol, putting people on pretrial supervision, and we'll get a lot to that later. Adding electronic GPS or alcohol monitoring. There's a myriad of different conditions that can be applied. It just depends on the judge's decision, maybe the nature of the offense, the conditions of the defendant as far as address, family status, job status, anything like that. Anything that the judge can determine will help the defendant show up for court and mitigate any risk that they may be rearrested. The judge can add. So they will put these on a bail bond as well. Now, once the judge has finally made a decision, he's gathered all the information that he needs, and he wants to actually set a bail, then the defendant has to go about posting their bail. The only time they actually have to post bail and exchange money is if the bail is a straight or a percentage amount. To do that, they can go through a professional bondsman. A professional bondsman will require a percentage of the cash amount, and that money is not refunded at the disposition of their case. The difference here is if your bail, for instance, was $25,000 and you happen to have the full $25,000, you could post it, but if you go through a bondsman, they're going to collect a percentage of that, and I typically see between 5 and 10% that the bondsman will collect, and then the bondsman is guaranteeing the rest of that bail amount and acting as a surety. But because this is their service and this is what they do for a living and they're the one on the hook for it, that amount of money is not refunded at any point. Again, you can post the full $25,000 yourself if you happen to have that kind of money. If you do that, then at the end of the case, when everything's disposed, you would get that money back. You could also use real estate as collateral. We don't see a whole lot of this happening, but if you happen to have property or your mom or dad are willing to post your bail for you and they have property that has an equity value equal to the amount of the bail that is needed, they can put a lien on the property for that bail until the disposition of the case, and then that lien would be lifted. And technically, they can also post government bearer bonds. I have never in my 24 years seen this one actually used. And when I was reviewing all of my bail rules and everything, just to make sure I was covering all of this, I actually had forgotten about this one. But if you have some bearer bonds, you could use those as well. So we talked about a little bit about the conditions for pretrial supervision. One of the things that the judge can do is order as a condition of your bail that you'd be supervised by our agency. And to understand that, I'll review a little bit of the history of pretrial, what pretrial is meant to do, some barriers to implementing a pretrial program, and where does Dauphin County pretrial stand in the grand scheme of things. First, a little bit of history. The first real mention of any pretrial program that you'll find is back in 1961, the Manhattan Bail Project, initiated by the Vera Institute of Justice, started going into jails that were overcrowded and seeing by staggering numbers how many people were being held for nonviolent, low-level offenses, and they were just too poor to post their bail. Their bail could have been something as small as $500, but they just didn't have the money for it. So they started interviewing those defendants who couldn't pay their bail and talking to the judges and starting to basically work with the judges and say, hey, you know, this person is pretty low risk, it's a low-level offense, maybe we can release them anyway, and they have a low risk of failure to appear. So that started in 1961, and many of the interview practices that were used back then are still used today. A lot of the same questions are still asked of the defendant. Then back in 1966, we go forward a little bit, and we have the first Bail Reform Act, and now pretrial programs are starting to pop up, and they're actually starting to be very forward-thinking in their practices by interviewing defendants before the judge considers their bail release decision, and providing that information to the judge and sort of giving them an overview of the defendant before the judge even sees them. This act also created the presumption of release as the least restrictive condition on a defendant, and that, you know, we are not looking at a defendant as, you know, why shouldn't I put you in jail? It's give me some good reasons so I don't have to put you in jail. And then we also started the practice of actually supervising the bail while the defendant is out. And we'll get a little bit more into bail supervision practices here in a little bit. And then we had another Bail Reform Act in 1984, which included public safety as a factor for determining bail. We didn't want to just make sure that the defendant was showing up, but we also wanted to make sure that they weren't getting rearrested. And in doing so, it furthered the need for pretrial programs to assess risk and provide supervision. So we get into the beginning of risk assessments a little bit here, and we'll be talking about that a little bit as we go along as well. And then the supervision really started amping up a little bit in the process for pretrial. So a little pretrial 101, you know, what are pretrial programs really meant to do? We provide the bail authority with information to assist in all bail decisions. So we're interviewing the defendants, talking to them. Do you have an address? How long have you lived there? Do you have a job? Do you have family support in the area? And then we provide all of that information to the bail authority with a release condition to help mitigate risk. So when the judge says, okay, you know, this is somebody we can release, we can supervise them, and we're telling the judges this is somebody who might be eligible for, or at least a good candidate for bail supervision, and the judge can put them on pretrial supervision to help mitigate the risk of either failure to appear or getting rearrested. And then while they're out on bail, we're providing them with resources necessary to ensure a successful pretrial period. This is kind of a situation where, you know, let's make some use out of that time instead of just sitting in a prison somewhere waiting for your court date. While you're out, let's make good use of that opportunity to start addressing some of the things that put you in this situation to begin with. If there's drugs and alcohol or mental health, we can refer for those services, you know, and help point you in the right direction, even if it's just something as making sure that you know that while yes, you do have the the right to represent yourself, that's never a good idea. And we can point them in the direction of the public defender's office and help them understand what they need to do in order to do that. And we provide the courts with compliance reports on the supervision process as well. So not only we, just giving this defendants to work with them, and then the judges just trust us to do whatever, but then we're giving that feedback back to the judges to say, okay, so you did release this person and this is how they're doing. So that at any point during the process, if things are going well, we can give them a pat on the back, and if it's not going well, then we can reassess their bail situation if it's needed. And why do we do it? All of this to accomplish what? Right here, we're getting higher release rates, which is reducing the prison population. One of the things I often tell my commissioners, especially at budget time, is we have approximately almost 2,000 people on supervision, and if half of those people couldn't be on pretrial and had to go to DCP because we weren't available to help them, where would you put them? And right now the prison's already overcrowded, so that would cost them a lot more money to add on. It helps to reduce failure to appear rates and rearrest rates. We make sure the defendant knows what their court date is. Sometimes people move a lot, so we make sure that they get their court appearance dates and remind them that they have court coming up. And then if we're addressing some of those issues that got them there to begin with, hopefully that reduces the chance that they're getting rearrested for the same thing. We begin the process of addressing a defendant's needs. Again, the drug and alcohol stuff goes to the rearrest rates and saving taxpayers' dollars. It costs a whole lot more to house somebody in Dauphin County Prison than it does to run a pretrial program. I think the last number I had, if we had to add on to the Dauphin County Prison, it would cost them approximately $25 million. Our annual budget is roughly $800,000. So, you can do the math and see how long it would take them to save that kind of money if we weren't around, if they weren't investing in us instead. Little pretrial 101, a little bit more here. Barriers to implementing a pretrial program. Pretrial programs are successful, but not everybody has one. And there's a lot of reasons for that. There's a lack of education on pretrial practices. I can't tell you how many times I've been asked to do a guest lecture at some of the colleges because there are not enough information on pretrial programming. And even in law schools, there's not a lot of talk about pretrial programming. Sometimes it's covered a little bit when they have a course titled something like Alternatives to Incarceration. But I still have people apply for jobs here that have never even heard of it. Not every county has one. In Pennsylvania, we have approximately, just a little over half of the counties in Pennsylvania actually has a pretrial program. Even rarer still, there are states that are state programs. Kentucky, Ohio, Maine, Virginia, they have state-run programs, but the problem is it's not a mandated kind of thing. Not every county truly needs one if they don't have a lot of prison overpopulation. It's not to say they couldn't use one, but there's no dire need for it, so they haven't started one up. The ones that do have pretrial programs, not all of them are run the same. Some of them are state agencies. Some are actually county departments. The state agencies are the ones like Kentucky and Maine and Virginia, and then they have the county departments, where it's a standalone department within the county. You have embedded departments, and that's where we see a lot of the trends going right now for pretrial programming. A lot of counties are moving to starting pretrial programs up in their probation departments. We've also seen some starting up in court administration and even out of the jails. You also have nonprofits. We are actually a nonprofit. We're one of 4 that I'm aware of in the state that is a nonprofit. And then you have the ones that are actually contracted agencies. This is not something I'm a big fan of, just because those contracted agencies, they are for-profit agencies. So the more defendants they have on supervision, the more money they make. And I think that's not really the way to go about things. But sometimes that's what you have to do in order to get a pretrial program started in your county. So something is better than nothing. And then another problem sometimes is just getting buy-in from key stakeholders. I know in Dauphin County, when we first started up, one of our favorite stories to tell is one of our judges who's now fully retired, he's not even a senior judge anymore, liked to tell the story about our then director coming to see him and him chasing him out of the office, telling him he didn't want any hug-a-thug in his office and all this liberal stuff that he was spewing. But now we'll just sing the praises of pretrial programs. It's important to make sure that everybody that's involved understands the nature of a pretrial program, what they're meant to do, what they're not supposed to be doing, and letting them do their jobs so that they can try to make the most out of the resources available. And then our office comes into play. Through the years, we were actually established in 1972, still as a nonprofit, as I said, one of 4 in the state. We were created originally as a bail fund. A lot of church groups got together and put a kitty together, and started actually bailing people out. There was no real interview involved. It was community based, so everybody knew everybody, and you could go to them and say, my son's in jail, and explain the situation, and if they could help, they would. So there was no interview or supervision involved. Once the person was released, again, it was just back into the community, and hopefully, the whole idea of it takes a village came into play, and they really helped them out that way. But it wasn't what it is today as far as supervision practices go. Then in 1992, we were recognized in the local rule of court as the official county bail agency. That really established us in the county in order to help out, but we were still more of what I call a catch and release agency. We would do interviews out at the prison. We weren't really doing anything on the front end before the arraignment. So once the defendant was already housed in the prison, we would interview them and then notify the court saying, hey, this person probably could be released. And back then we only had a caseload of about 35 people. There wasn't a whole lot of people being released on supervision. And the supervision itself was pretty much nil. The most we were doing was just simple court reminders. But then around 1999, early 2000, we started the program in night court, where we were actually present for arraignments and began the supervision process and began attending court hearings. And that really made a big difference in not only our caseload, but also visibility with the judges. They actually started seeing us more involved. And then they were actually using us more frequently, since, if you're not there, out of sight, out of mind, but since we were right there kind of in their faces saying, yoo-hoo, remember us, you can put somebody on supervision, the numbers started really ticking up. And then we started attending all the pre-arraignment interviews with the opening of the booking center. Again, out of sight, out of mind, but once we were actually in the arraignment interviews, because it was centralized at the booking center, we could actually be there beforehand. If it was an arraignment out at the district judge's office, there's 15 of them, and at one point even 16 of them. There was no way we had that kind of staff to have somebody at their offices all day, just in case they arraigned somebody. But now that we have a single point of entry out at the booking center, all of the pre-arraignment interviews were being done there so that we could interview anybody being arraigned. And that's when we also started implementing the pretrial risk assessments. So where are we now? Now we're present for pre-arraignments. So with that, we do the risk assessments. And I know I was a part of a discussion earlier with the previous program that we did with Chad Libby on risk assessments and risk needs. I went over this just a little bit, and I'll cover it again a little bit here as well. We started out with the Ohio risk assessment because it was part of the risk assessment toolbox that was being used throughout the county. And we started trying to move in with that a little bit, and it's kind of cradle to grave. There's pretty much a tool in that toolbox for just about every department that's in criminal justice. The problem with that was that a lot of our judges weren't really buying into that particular tool. So we had to back off a little bit. They were very concerned that it wasn't measuring what they consider risk. So rather than spoil the well, on a risk assessment that they didn't like and then turning them against risk assessments in general, we backed off a little bit, reassessed, and we moved in with the Allegheny County pretrial risk assessment. The biggest reason behind that was a couple of reasons, really. It was kind of twofold. One, it is a twofold assessment. It not only assesses failure to appear, but also a risk of new criminal activity. And also because it's already been validated and a tool in Pennsylvania. So a felony in Allegheny County is a felony in Dauphin County. If we had moved to a tool, say, from Virginia, then we might have to recalibrate some things because not everything in Virginia is the same here in Pennsylvania. The title of the charge, the grading of the charge, all of those things come into play. We've been using that since about 2018. And right now we're going through a lot of validation work. It's very heavy on data. So what we are doing is just sort of going through and trying to make sure that indeed all of the questions that are being asked on that does provide a statistically relevant risk value on a defendant that meets that kind of criteria to say whether or not they would indeed be a certain level of risk for failure to appear or new criminal activity. At this point, when COVID came into play, we had to back off a little bit out of the booking center. One less group of people coming in and out of the booking center was a good thing. Also, we were considered kind of not mission critical because the judges were supposed to be releasing as many people as humanly possible anyway. It had to be pretty dire circumstances to put people in DCP during COVID, especially at the height of things. So we backed out a little bit, but in trying to reinstitute the risk assessments, we've been passing the baton to the diversion specialists that are out at Dauphin County Prison. Again, it's fewer people in the mix, and it is pretty crowded in there. There's not a lot of room, and with all the other responsibilities that they already have, we decided that we can have them do those as well and keep a fewer number of people mixed into the pot down there. So the diversion specialists out at the booking center are actually picking up the risk assessments. What we're doing now is we're sending in arraignment reports instead. And these can be done virtually, which is really nice. So any time of day or night, even if we're doing it from home, we can send a report directly to the judge, whether it's at their office or at the booking center if they actually go in instead of doing it virtually. We can send them a report that addresses a lot of the risk factors that we can determine. And most of them are simply if there's a history of failure to appear, if the defendant has any pending criminal charges, if they are already out on bail with pretrial supervision and how they're doing, or if they have a history of pretrial supervision where they've been on with us before and how they did at that time, and if we're able to ascertain whether or not they're already on probation. Now with supervision practices, things really haven't changed. Even with COVID, we're still making referrals for services. So anytime anybody comes into our door, we're again trying to make the most use of the time that they're out on bail by referring them for just about any human service need that's out there. The most common ones, the drug and alcohol and mental health, are obviously the biggest ones that we see and the most common referral services that we end up making. But even things like parenting classes, or anger management or batterers classes, we can make referrals for those. There are even programs out there for, say, retail theft. I think there's a class out there even for STDs. Not that we talk about those a lot these days, but it's out there. A few more supervision practices. We do still remind defendants of their court dates. Dauphin County has been moving to another system where defendants can also get texts or emails, which is really wonderful. It's a nice technological step in that direction. But even when they're checking in every week, we're just saying, hey, when's your next court date? Are you ready for it? You have that on your calendar. We do some drug testing. They are witness samples, so it gives them a little bit more accountability. It's not just that we tell them that you can't use, but we're also trying to make sure that they're not using. And if they do use, then we can reassess whether or not there's any need of either further evaluation or a new evaluation if they haven't already had one. Drug testing can be a little bit complicated. We test for the major ones, obviously, you know, the marijuana, the heroin, the cocaine. Getting into some of the other things, we can test for alcohol, but we don't get into a lot of the synthetics, and the biggest reason for that is because the synthetics, the chemical compounds for that change almost daily, and it's almost impossible to keep up with it. So the chances of actually catching somebody and getting a positive drug test for synthetics is pretty rare. But the major ones are still covered, and this is at no cost to the defendant unless it's something that's really technical, like the synthetics. Then there might be a cost for that. But otherwise, all of this is part of the supervision. We also have the electronic GPS monitoring and alcohol monitoring. Those can be used for a myriad of reasons. We do have some judges that just like to have the electronic monitoring set on somebody. That's a pretty extreme condition. We try to encourage them to only use that for more extreme cases where there's higher risk. But a lot of that can be something as simple as just making sure that they don't leave the state, that we always know where they're at, or something more extreme like a house arrest situation where the judge has ordered them to be on house arrest and we can make sure that they're actually at their home when they say they should be. And the alcohol monitoring, the monitor that we have available to us, it actually connects to the skin and can detect alcohol consumption through the skin. So we use that a lot in our DUI program. And sometimes if there's an alcohol involved incident, maybe it's a domestic violence or something like that, and you know, alcohol has fueled the incident, we can also put them on an alcohol monitor for that. That has to be court ordered. That is not something we just initiate on our own. That has to be specified in the conditions of the bail. Then we report to the court what's going on. We provide compliance reports at any given point during the process. They are sent automatically to the preliminary hearings. I know one of our judges really likes the compliance reports and kind of refers to them as report cards for the defendant. But we can also send them at any point that they're requested, whether by the district attorney or their defense attorney, so that they have them for the record, whether it's for sentencing or for a pre-sentencing investigation or anything of that nature. Sometimes the report to the court has to be a request for revocation of bail. This is usually a last-ditch type of thing. It's the extreme when somebody is getting rearrested, or maybe the substances that they keep testing positive for is putting them in jeopardy of actually overdosing. We can request a revocation of bail. We don't always request a revocation just because somebody got new charges, depending on when the charges occurred, the nature of the charge. If it's been, for instance, a string of car break-ins, it's kind of all one event. Or if it's for a really minor charge, and they're only on for supervision for a really minor charge, then we wouldn't necessarily request a revocation, because actually bail, putting somebody in a jail on bail is always the last resort. We also provide testimony. We've actually had to go to court sometimes, and it's always interesting when we're on the other side of the fence a little bit. I've actually had to sit in the witness box and raise my hand and swear to tell the truth and the whole truth and be questioned and then cross-examined. But we do testify for the court how the defendant is going. If there is a bail hearing particularly, then they are entitled to a bail hearing, and then we would be actually called to testify. And then of course we give that compliance information for any pre-sentencing investigations that are being done, so that when the judge is asking for a whole lot more information on the defendant and getting a better background check from probation, probation will call us and we'll tell the probation officer how they're doing. Our current caseload is about 2,000 cases. We just nudged down just a little bit closer to 2,000, but even with COVID, we were up to almost 2,100 cases with an approximate appearance rate, and I have to stress approximate, and I'll explain that in a few minutes as well. There's an approximate appearance rate of about 93%, which is really excellent. That means there's only about 7% of the people that are put on pretrial supervision actually fail to appear for their cases. Pretrial is involved in a lot of the criminal justice process, and this is just a sort of a general list of all the things that we're doing. We're on the Criminal Justice Advisory Board. You know, as part of the criminal justice program, we want to make sure that we're letting everybody else know what we're doing, how we're doing it. We're part of the bail review team. Bail is our business, so we want to make sure that when they start reviewing bail, that they know what our assessments have been, what our information on the defendant is, and then of course if they want to consider putting them on pretrial, it's nice if we know about it. We're also involved in Team MESA, the Mental Illness Substance Abuse team. So if somebody has been identified as somebody in particular need because of a mental illness or substance abuse, we can address conditions that way. We have a new court program called Recovery Connections Court. I was limitedly, but part of the planning team and in offering suggestions as far as bail conditions and our participation in helping that court get set up and going, and the sort of stopgap measure for people who are released on bail until they can get into that program. We're part of the Stepping Up Committee, which is an initiative to reduce the prison population of people who are there with serious mental illness, or at the very least reduce the amount of time that they're there. Part of the Data Committee, that's a big thing that we're really pushing, is to make sure that we have good data. And that's been a struggle for us because of the software that we have, and I'll get into that here in a few moments as well. But we're part of that as well, so that, you know, we can back up what we're doing with real numbers. We're part of the Reentry Committee, and there's also, and now it's a coalition. It sounds a little bit backwards, and why would we be there? But really, part of reentry is actually trying to make sure that people don't go to jail to begin with. You don't have to reenter if you've not been there. So if you can prevent it on the front end, you want to make sure that you talk to us so that we can try to get involved in that and try to reduce those numbers as well. Drop Court is our DUI repeat offender program. So people who have multiple DUIs, especially in the close timeline between them, can be put in drop court, where we will have an alcohol monitor on them, and we are very much involved in that because that's all a pre-sentencing thing, so that while they're out on bail, we reduce the rates of DUIs. And the BRAT committee, which is the bail risk assessment team, that's the big thing for the risk assessments, in making sure that we have a good tool and validating that tool. And then when the tool is validated and we can figure out, you know, what questions are working, if we need to reassess the tool itself or maybe just tweak some of the questions or scoring, we all work together to try to accomplish that. One of the big things that we did back in 2016 was the DCP Population Study. One of the things that I had seen time and time again, and it frustrated me to no end, was this misnomer that, or at least a misconception, that 70% of the prison population is unsentenced. And to the layman, that would mean that 70% of the people there are being held on bail. And every time I would hear that number, it would almost set my hair on fire. It drove me crazy because I knew that that wasn't completely 100% accurate. It was a little bit of a misrepresentation of what that really meant. So we took the prison records management system and we tried to ask them, you know, can't you break this down? But unfortunately, the prison records management system can't break down the population in that kind of way. If you ask for a list of everybody that's there on bail, you will also get a list of everybody that's there on bail and something else, whether it's a sentence or a detainer or some other court order. It won't give you just the people who are only there on bail. So we literally, with a number of different colored highlighters, a different number of different colored pencils, and a brand new set of glasses, went through and counted the population and found that for a population of 1,030 people, only 24 were being held there strictly on bail. 32% had a bail and a detainer, so that 32 and the 24 still doesn't really quite add up to 70. 28% were only there on detainers and 16% were there on sentences. Now, when I say detainer, I don't mean necessarily just a probation detainer. A detainer could be anything from a probation detainer to a state probation detainer to a ICE detainer to a court order, maybe non-support. anything like that that could hold a defendant that's not a bail. So that was really eye-opening. We wanted, as part of all of our job in trying to reduce the prison population of people who are out on bail, saying that 70% of them are unsentenced, so many people assumed then that that meant 70% were there just on bail. And we thought that was really important to delineate and make sure that that was addressed as well. So what's next for pretrial in Dauphin County? Data, that is a big thing. As I said before, there's the things that we're trying to do is just reinforce that what we're doing is working, and the only way to really prove that is with data. So we're validating the risk assessment, and hopefully that will be completed this year. We were kind of hoping that we'd be able to give you a whole bunch of data with regard to that, even in this presentation, but unfortunately, we had some difficulty gathering the data out of the software, which is where the next key component comes in. We have new case management software coming, and we're very excited about that. The software that we have has been wonderful as far as managing defendants and case management, but as far as data collection, it's very difficult to actually pull it out of this software. So that's delayed some of the risk assessment validation as well. But hopefully we'll get some new software coming in and getting that up and running, and we'll be able to pull better data out of it. And then of course we probably need to do another prison population study. We're also looking at trying to find ways that we can get that information out of the prison court management system. But until then, it might mean, a couple weeks poring over some, a day in the life report. But if that's what we need to do, that's what we'll do, because that's really important to consider anytime you want to revalidate whether or not your work is actually working. And then there's going to be more collaboration, more research, more education, more hard work. It never stops. You can't just say, well, we're doing it and everybody knows about us, so that's good, because that's not really true. Things change. We're looking at getting some new judges in Dauphin County. That's a big thing. So we'll be educating those judges and letting them know how we're doing things, why we're doing things, and what we can do to help them. So, and we're collaborating more and more with other departments. As I said, we're having the diversion specialists out at Booking Center also working with us with those risk assessments. So there's a lot more collaboration. So there's not a lot of duplication in services that way. And hard work, it all adds up. We have to continue plugging away. A little bit of blood, sweat, and tears goes into this, just to keep things moving along. So wrapping it all up, and we're actually going to finish up in plenty of time for questions and everything for you, and maybe even give you back some time from your day. But wrapping it all up, we have 15 MDJs and 9 common pleas judges that set bail. That's a lot of people involved in the system. They have a criteria of 10 things to consider when setting bail and 6 kinds of bail that they can set. So you're compounding decisions and adding more things for them to weigh when they're doing that. They have a myriad of conditions that can be considered when setting bail. So not only do you have to make up your mind what kind of bail you want to set based on what kind of criteria you're looking at, but then, what else can you do to help keep the defendant on track? And then with our supervision being part of that equation, we add a lot to the number of facets that can be put into play with the bail decision. And unfortunately, there's no formula for any of that. You can't just tell the judge, well, this defendant, he's 1, 2, and 3, and that makes 6. So this is what you should do, and this is how you should do it, and this is how we're going to supervise them. Every defendant is an individual. Each person is different, and we need to treat them that way. We need to make sure that we're remembering that they're innocent until proven guilty. Their needs might be different. Maybe they don't have a mental illness, but they have drug and alcohol, or vice versa. Or maybe neither, and maybe they just have sticky fingers and they have a history of retail theft. But we need to address all of those different factors. So each person is individual, and we need to make sure that we're handling it that way. So then the real question might be, well, with all of that to consider, how do you get anything done? And that's with 5 simple words. And that's just one case at a time. Our case management software measures a case by case by case, not individual. So we have to remember, you know, each case is different, each defendant is different, and we need to handle it that way. And the last thing I want to leave you with is a nice little quote. It's my favorite of all time. Excessive bail shall not be required. And it's nice because that's actually right there in the good old US Constitution. The only problem I have with that is who gets to decide what is excessive. And that is a question I always ask the classes I teach when I do some guest lecturing. You know, I will say, give that quote and say, who can tell me what's wrong with it? And I'm always delighted when the first hand goes up and they say, who gets to decide what is excessive? And in our system, that's those 15 district judges and the 9 common pleas judges that have those decisions. And so much goes into it, it does sometimes make it hard to keep it all within the lines. With that, I will thank you for your time and open things up for questions. If Catherine wants to turn things back on or shoot anything my way, or if you want to send anything through the chat boxes. I don't know if anybody submitted questions ahead of time.
I didn't see any submissions ahead of time. One comment in the chat was just confirming that pretrial used to be run by volunteers, and that was the case years back. I did see, well, I had a question actually I've never actually asked you this before.
Oh.
Case by case, it varies, right? But roughly, what is the average time a person spends on pretrial services?
Oh, you know, I would love to be able to answer that with an actual number of days, but you know our system, you know my frustrations with that system. I have seen cases be closed in as little as 1 day, and I've had people on supervision for as many as, and this should blow people away, as many as almost 5 years. That is obviously an extreme, and that should in no way happen. When we have cases like that, they start out checking in with us maybe once a week, and we're keeping touch with them and stuff like that. But as they go along, we're able to back those things off as we see that they're not getting rearrested and they're not failing to appear for court. We can make it so, you know, hey, just touch base with me once in a while, or maybe we will call them. And then we start calling the district attorney's office and their lawyer, their defense attorney, and saying, hey, what's taking so long? They've now done more with us than they ever would with probation. But that's an extreme case. If I had to put a number to it, I would say anywhere from 2 weeks to a year, depending on the nature of their case, if they're actually taking a trial, what happens at the preliminary hearing. If it's disposed at the preliminary hearing, that's nice and simple. We can be done pretty quickly. But if they want a full trial, juror of their peers, the whole 9 yards, then yeah, that gets pretty lengthy, and we can have them on supervision for a year or 2.
Okay, great. If you had to name one thing, and I know this is hard when I understand from your presentation, which I thought was outstanding, all of the complex factors that go into this. If your agency had like one thing or like one need that you think could help address what happens in the community, what would you recommend for us to focus on?
Oh, something you could actually do. I was going to say a crystal ball. The one thing we could focus on, I think, is just resources, you know, and consistency in those resources. Resources, just like defendants, just like criminal codes, the judges themselves, all of our resources change. But the demand for resources, particularly drug and alcohol and mental health, is really, really high right now. So the more resources that we have at our fingertips is the better that we can do our jobs. So if there's ever one particular thing that I would ever beg for consistently, it would be resources.
Thank you, Shannon, very much. I want to turn it over to some folks. Does anybody have any questions that Shannon you can either put them in the chat or, oh, I see somebody in the chat box. Okay,
yeah, I know I talk fast too, so if I blurt by through something.
I resemble that remark. I talk fast as well. And she's laughing. She knows it's true. Okay, question from Darlene. If someone has been in DCP for 3 years, is he still seeing, or would he still be seeing pretrial services? Is there any help that person, if he is for that person, if he or she is released to the community after his trial? So a couple variables there, but you might be able to see that in the chat if you can pull up that box.
Yeah, just addressing in general, it depends on what they're in DCP first. If they're in there on a sentence, then there's absolutely nothing we can do. But if they've been in DCP for 3 years and they're in there on bail, their attorney really should be advocating for a release of some kind. It's not something that we're able to do. They would have, if they've been in there for 3 years, they've probably gone through all the screening stages that we have that we could address it with our bail review team, or even Team NISA if they had a need for that, or even some of our specialty courts. We have drug and alcohol, drug court, we have veterans court. We're looking at reinstituting, the county is reinstituting maybe a mental health court. So there's a lot of resources available for somebody to be sitting in DCP for 3 years. If they're sitting there in there for 3 years, there's something wrong in the system with that, for that particular defendant, because they actually have the right to a speedy trial. So if they're in there for that long, that means something's going on the defense side that they're not getting them into trial yet. I would have to imagine it has to do, it's a pretty intense case and very technical case, a lot of discovery, maybe a lot of a need for scientific evidence type of stuff, whether it's DNA or professional witnesses or something like that, that would be required. That would be the only reason I know of that it would take that long.
And then just to follow up, I think she wrote attorney as PD, just adding a little more context even to that. Just as Shannon said, there could be multiple reasons a person is held. It may not be a case where there's something that the county itself is in control of. We often house folks in Dauphin County Prison for any number of reasons. There could be federal or state or other detainers, and we simply house them there. So there could be, it's hard to answer just for one case. There could be multiple factors. I know for severe folks with severe mental health diagnoses, as an example, if they're waiting to maybe reestablish competency, that takes time and the person comes back. There can be any number. That is a pretty high number without a sentence for somebody to be staying there. But again, there could be any number of factors. Is there, okay, she's asking a couple more questions in here. Just one piece to your question, I think, Darlene, that wasn't answered. Is there any help for that person if he is released? Well, that, again, is where pretrial could step in if the person is truly unsentenced.
Yes.
But if the person is released and has been sentenced, for somebody who maybe be spending that much time on pretrial, my guess is, and it would be case specific, that person may be paroled and provided probation services at that time, given an officer, that sort of thing, as a part of his or her sentence. In terms of discharge planning, we do now have at Dauphin County Prison an individual in the treatment department who's doing mental health reentry plans, case plans for folks that are going through the system. It's not completely comprehensive. In other words, every single person going through the jail, not every single person gets a full reentry plan. But this individual, if that person is identified with a severe mental health diagnosis and or co-occurring substance use disorder, they will get case planning. The jail doors locally turn so fast. At the state level, somebody is in 2 years plus roughly. There's plenty of time to do this reentry planning. Locally, someone can be in and out of the jail within a few days. So it really depends on the case, how fast somebody is being discharged, kind of why they were there. But if someone is sentenced and reentering the community and has that treatment need, we now have an individual who's able to help us a little bit more with that case planning and connection to services. And then also, if the person has been on pretrial during that time, maybe got revoked, we'll have some of that cases, and pretrial works very closely with probation. Shannon and her team will talk to the officers, give them some more of that background, what they're able to provide, and that helps in terms of that broader context to support that individual. So I hope that answered your question, Darlene.
Yeah. Two more points to make to that, Catherine, is one, if any pretrial involvement, while we can't go into the jail and start advocating for a defendant, that's really the defense attorney's job, especially if they're a paid attorney. We're not in the position to do that, and we can't just pick up a case. In order for us to be involved and actually supervise the person, it has to be ordered as a condition of their bail. And as far as cooperating with probation, if it's something that, you know, needs to be passed along to probation once they've completed pretrial, that's one of the things that we're looking at with this new software, is we're going to be on the same platform with probation. And this is the first time that's ever happened in Dauphin County. And we're looking at some availability, or a bit of just general ability then to actually open the case once they've been supervised and they've been put to probation, that we could then transfer actually basically the notes and all our history with that defendant to probation, where it's HIPAA compliant.
Yeah, so that's a great question. And I know often as we're doing these, folks maybe have individual or specific case questions they have, and those are all great to discuss, because there could be any number of reasons something happens within the system. And these are kind of like the broad strokes of, you know, what generally should happen. And then we can dig deeper into, you know, individual, you know, as the situations arise. Any other questions we can address? If not, I think Shannon provided her contact information. Absolutely, please email her, or my email probably went out as part of the registration, or you've received an email from me. You know, can email me or reach out and let us know if there's something else you have a question about. I do have, Shannon had mentioned a report that we had done earlier. I do have the first phase of that kind of initial overview of Dauphin County bail practices. I've sent it out to several folks before. If you want a copy of it, just let me know. You can put something in the chat saying, send that to me. I should have your email address from having signed up for this session, and I can send you that phase 1 report. It's that second phase of the impact of what we're doing now with the risk assessments that we're currently kind of working on. And coming up then, we have these every other month. And again, the topics were selected by folks in the community. Our next one is going to be in drugs and alcohol, mental health, treatment needs. So you'll probably hear from a few folks on our drug and alcohol program, some parts of our Stepping Up initiative, some of the reasons, and you know, we've made some changes in our system and how we're still working to improve in those areas, and maybe learn a little bit more about some of the programming. And then you know, 2 other ones coming up probably after November, or in the fall, we'll do a reassessment of what additional topics folks may want to see, and continue from there. Any last closing remarks?
I appreciate everybody signing up and letting me talk about my job.
Yeah, I really appreciate everybody coming out today. And Shannon, thank you so much for your expertise and all the work that you and your folks do. Oh, Shannon, can you go back 1 slide and put your contact info up again?
There you go.
There you go. All right. Take a screenshot of that, or I'll just read the phone number, 717-780-6441, or sdanley, SDANLEY, at Dauphin, the letter C.org, sdanley at dauphinc.org. Okay. With that, everybody have a wonderful afternoon, and hopefully we'll see you at the next one in July.
Thank you very much.
Thanks,
Thank
everyone.
you.